Hey, Tony DeWitt here, Missouri Appellate Attorney. I'm retired, and this is not legal advice. Everything I say is simply commenting on the law, and this will be what we're commenting on today. Let's do a thought experiment. Let's imagine that you bought a brand new car. Let's say it was a Mustang GT. And let's suppose that you really wanted to find out what that car was made out of, but you didn't want to endanger anybody on city streets. So you decided the best place to do your testing was on the Oklahoma Turnpike at 3 o'clock in the morning. So you go out onto the turnpike and you spool up that Mustang and you're able to get it to 140 miles an hour before you realize you just passed a state trooper. Now, being smart and knowing that nobody ever wins a battle with a state trooper when they're speeding, you do the one smart thing that you can do at this point, because you know the guy could pitch your vehicle. You immediately drop your speed, pull over to the right so the police officer doesn't have to chase you, lower your window, and you're polite to the officer. But in spite of your compliance, the officer is upset and he's duty bound to arrest you for criminal speed because you were going over the speed limit by more than 20 miles an hour. So he tells you to get out of the car, cuffs you, takes you to jail, has your car towed. You bond out, you hire a lawyer, and your lawyer goes to the prosecutor and asks to see the evidence. And the evidence says, well, the radar didn't get a really good lock. It looks like he was going about 89 miles per hour, but that's still criminal speed. So, that doesn't sound right because my client told me he was only going 80. So that isn't really true, but the state prosecutor doesn't know that. The trooper can't prove it because he's not got a good radar fix, and you slowed down and you only got caught doing 89. So the prosecutor decides that he'll make a deal. If you'll pay a $1,000 fine, that'll teach you, you speed freak, and do 40 hours of community service and promise not to drive above the speed limit for the next year, she will give you a break. She will null prosequi, or null pros, your charges, which just simply means I'm exercising my discretion as the prosecutor to let this one go. I'm not going to prosecute it. So the deal means you're not going to have a speeding on your license and your insurance rates aren't going to go through the roof. It's a good deal for you. Now let's suppose that the time comes for the court date and the trooper finds out he doesn't need to go to court because there's no case there. He goes to the state attorney and says, what gives? And she says, well, I made a deal. You only got him going 89 miles an hour. He says, yeah, but he was going a lot faster. So he goes and he gets access to the state highway department, gets the highway cameras, the surveillance cameras that everybody knows are there. And knowing where those are, he calculates your speed at 138 miles per hour, 138.9 miles per hour, because he had you at this point and at this point, and it took you X number of seconds to go that far. And as a result, he can calculate it at 138 miles per hour, which is pretty close to what you were doing. Now, he does this in his spare time, and it takes him several months to get all this information together. But by the time he does, you've already done your community service. You helped out at Goodwill, and you've paid your fine, the whole $1,000. I mean, if you can afford a Mustang GT and you can afford to drive, that fast, well, it wasn't hard to pay the fine. But now the prosecutor says your lawyer wasn't honest, and as a result, they're not going to honor the deal. They refile criminal speed charges because they promised not to prosecute 80 miles an hour, not 138.9. Well, now, that doesn't sound very fair, does it? But at least in some states, that might actually be allowed. But not in Illinois. We all remember Jussie Smollett. Jussie was a barely famous actor working in Chicago in 2019 on a show I never watched called Empire. He was also, not that it matters, openly gay and African American, but it apparently mattered to him, and he cooked up the idea of a racial/homophobic hoax to boost his career. But like nearly all the people who engage in stupid things. He didn't really think it through very clearly. Smollett was caught for faking the attack through a series of investigative steps taken by the police department there in Chicago. When Smollett came in and reported the crime, he said that two men attacked him, yelled racial and homophobic slurs, poured a chemical substance on him, and tied a rope around his neck. So they're duty bound to investigate, and they do. They begin investigating the incident and they collect surveillance footage from the area. They identified two persons of interest shown in the footage near the location of the reported attack. So the two individuals identified were the brothers Olabinjo and Abambola Ozendario. They were taken into custody for questioning. Now, the brothers are known to have some connections to Smollett because they'd worked as extras on that TV show, Empire, and they were acquaintances of Smollett. During police questioning, the Osandario brothers confessed that Smollett had paid them to stage the attack. They provided details of the plan, including the fact that Smollett gave them money to purchase supplies like rope and masks. Even more interesting, he had paid them for their services with a check, and it made it pretty obvious that he had reportedly been very much involved in staging his own attack. So, based on the brothers' testimony and the gathered evidence, Smollett was arrested on February 21st, 2019, and charged with filing a false police report. The police accused him of orchestrating the attack to gain publicity. After he reported this crime and after the investigation, he was hit with a 16-count indictment for disorderly conduct, not filing a false police report, basically disorderly conduct. Weeks later, the Cook County State's Attorney's Office dismissed the charges after Smollett completed community service and forfeited a $10,000 bond described as just resolution. Well, a lot of people in the Chicago area, actually a lot of people all over the country, felt that that was not a just resolution. Because of the backlash, the court appointed a special prosecutor who conducted a new investigation and filed additional charges against Smollett. A jury convicted him on 5 of those counts, sentencing him to probation, jail time, fines, and restitution. Smollett immediately appealed to the Illinois Court of Appeals, which is the intermediate level appellate court in Illinois. And I think to a certain extent, all appeals courts tend to have a bit of a what I would call a prosecution bias. And as a result, they affirmed the conviction. So at that point, Smollett could take this case up to the Illinois Supreme Court, which is what he did. So at the Illinois Supreme Court, the state made a number of arguments. First, they argued that dismissing the first case with a null pros, a decision which is basically not to prosecute, didn't prevent a new prosecution, and there was good law on that. They claimed there was no binding agreement with Smollett to drop the charges permanently. They asserted that even if an agreement existed, it was void due to the fact that the person appointed to handle the case after the prosecutor, the elected prosecutor, recused herself, was not in fact, somebody who was admitted to that office. So they believed they had the right to go back after Smollett. Reduced to its essence, the state's argument was, we got this really neat conviction of this really famous person, and we don't want to let it go. The problem for them was that the defense was arguing something that the argument of the prosecution didn't really cover. The defense said that the first dismissal was part of a binding agreement, meaning, okay, you can keep my $10,000 bond, and as a result, I'm fine with that. I'll do my community service, and then you drop the charges. They argued that reopening the case violated due process because he had fulfilled his obligations. Like the guy in our hypothetical, he had done everything he was required to do. And they also said, look, if criminal defendants can't trust the prosecutors to keep their word, you are going to undermine trust in the justice system, and you guys don't want to do that. The Illinois Supreme Court was really in a bad position here. They had a high-profile case that had been sort of unjustly null-prossed at the very beginning, then prosecuted, and now the argument was that doing this second prosecution violated due process as well as double jeopardy. And that was a fairly powerful argument for them. So this month, they overturned that conviction. Here's their reasoning. First, the agreement was binding. The court found that when the attorney's office entered into a clear agreement with Smollett, he performed his obligations and the charges were dismissed in return. That's offer, acceptance, consideration, and they closed the deal. There was nothing more that either party had to do to perform, and as a result, it was a done deal. The Supreme Court said by re-prosecuting Smollett, the state reneged on the agreement, violating his right to due process, violating his right to be free from a second prosecution when he'd already paid his debt on the first one. The agreements between the prosecutors and the defendants have to be honored to ensure fairness. And they also thought that the dismissal was final. Though the legal mechanism used, null pros, typically allows charges to be refiled, the agreement made here precluded this because they referred to it as a dismissal and a resolution or a disposition. In other words, it was intended to finally close that case. And there are public policy considerations here, as the court noted, and as, of course, Smollett had argued, that allowing prosecutors to backtrack on agreements erodes confidence in the justice system and undermines the fairness of plea bargains or similar deals. Essentially, what criminal is going to enter into a criminal justice plea bargain if he knows that the prosecutor can, when he gets up in front of the court, go, yeah, I know we told him that, but I think we're just going to take him to jail and throw away the key. That's just not a good way to do things. So, as a result, the court reversed the conviction from the second prosecution, ruling that the state couldn't prosecute him again after he fulfilled his obligations under the initial agreement. Now, here's the key takeaway. When prosecutors make a deal with the defendant and the defendant fulfills the obligations at the end of the bargain, the government must keep its promise. The court cited a lot of Supreme Court of the United States jurisprudence in reaching this decision. They said breaking these agreements isn't just unfair, it's unconstitutional. And the case reaffirms that trust and accountability are crucial in the justice system. Now, in some ways, it's a little bit like what happened with Alec Baldwin. There was no question that Alec Baldwin had killed Helena Hutchins. There was no question that Smollett had engaged in what appeared to be a racial hoax. The difference is that he was convicted wrongly. He had essentially admitted to disorderly conduct when he reached this first deal with the prosecutors. And going back and doing it a second time undermined the fairness of the system. Now, I was the first person to stand up and say when Baldwin was allowed to let go that that was a bad call on the part of the judge. I was wrong. And I was wrong because I diminished the impact of the due process rights that were violated. And in reading this case, although I wasn't too fond of what Smollett did, I'm never very fond of anybody who tries to create a hoax, to create, basically to portray themselves as a victim in order to get public sympathy or accolade. I don't like those kinds of things. I think they are an abomination. But in this case, even though I think he did the wrong thing, that's just my opinion, the court and the prosecution in this case did a far greater disservice to the Constitution and to Smollett by going back on the deal and re-prosecuting him. Now, I understand that may be an unpopular opinion, but the law needs to be enforced consistently. If you make a deal, you have to stand by that deal. Even if it's a bad deal, you have to stand by it. And allowing somebody to escape the deal that they made is just terrible public policy. So that's what I have for you today. If you have any questions, you can drop them in the comments down below. Like, share, subscribe. I always ask you to do that at the end. After you've seen the video, you know what you're getting. So if you liked it, please feel free to subscribe. And of course, if you have the opportunity today, do something nice for somebody. Doesn't have to be a big thing, just do a nice thing. And then come on back down here tomorrow, join me down here at the beach, and we'll talk about something else interesting. I shouldn't have to say this, but you don't seek legal advice from a guy down at the beach. You seek it from a lawyer in a lawyer's office, where there are people running around in suits and secretaries and all kinds of other people. I'm just a YouTuber. I'm a retired attorney at this point, and although I retain my license to practice in the state of Missouri, I am not here dispensing legal advice. I'm just offering general content on the law. And here are some videos that YouTube thinks you may enjoy.